Mr. Davis, I'm ready. Mr. Hammy, please start your video. Mr. Hammy, please start your video. All right. This is case number 234469801. The people of the state of Michigan versus Alan Hammy. The defendant is charged with 1 count of gambling disassociated person. Today is the date set for an arraignment. Mr. Davis, hold on. All right, there you go. Mr. Davis, your appearance, please.
All right, Maurice Davis, P76203. Appearing on behalf of my client, I will perform a reading of the charges in the plea of stand mute. And Mr. Hammond, state your name for the record.
Sir, state your name.
Alan Hammy.
Thank you. Court is going to enter a not guilty plea. On behalf of Mr. Hammy, set the matter for a pretrial conference. Court will set a pretrial conference for Mr. Davis, are you available on August the 10th?
August 10th. No, I have a trial that day.
All right. What about the 11th?
Yes, I'm available.
Okay. August the 11th.
Okay.
At 8:25. Esteban.
Esteban, Your Honor, my client is here as scheduled. He has retained counsel. This is a nonviolent crime, but ask the court for a personal bond.
Court is going to set bond in the amount of $500 personal bond. No contact with any casino, notwithstanding whatever his current status is on the disassociated persons list. All right.
All right. Thank you.
You're welcome. Anything further?
Nothing else. Thank you.
All right. We're all set, Mr. Hammy, until August the 11th. Have a great day. Stay safe.
Thank you so much. Thanks.
You're welcome. Miss Span, who's doing Hightower? Was that a student? Was that the student?
Yes.
Okay. Oh, wait. His iPhone keeps trying to come in, or I keep bringing it in, but it's not doing what it needs to do. Yeah, I don't understand why it would keep coming in if it's not even going to try to connect. I'm going to go off for a minute then.
Okay. Say hello.
Hello.
Okay. Thank God for the person who's helping you. All right. State your name for me, please. Unmute and state your name.
It's Miguel Ramon Gomez.
All right. And Mr. Gomez, someone is helping you. Do you need an interpreter, or they were just helping you with?
No, ma'am. I just never used this Zoom meeting before, so I wasn't sure how to use it.
All right.
The audio.
The audio.
Mr. Gomez, start your video.
Okay. Start video. Okay.
Mr. Gomez, I'm going to send you to a breakout room. A lawyer is going to come into that breakout room to speak with you. I want you to wait in that breakout room until someone else comes in there with you. Do not leave out of the breakout room until someone else comes in there to talk to you, okay?
Okay, that's fine. Thank you.
You're going to see a prompt come up on your screen. When you see the prompt come up on your screen, press to join the breakout room, okay?
Okay.
Mr. Isho, did you speak to Mr. Brantley?
Yes, I did.
All right. All right. And did you also speak with Hightower? Oh, yeah, because you're the only student here today. Mr. Isho is the only student today, right?
Yes.
Yes,
So,
Judge.
all right, so I'm going to do Hightower and then Brantley. All right, I'm ready on Hightower. This is case number 214511101. The people of the state of Michigan versus Tatanisha. The middle name is cut off. It starts with EM and then Hightower. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for an arraignment on a bench warrant. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Mr. Isho, you should be able to unmute. Let me see.
Oh, sorry. I didn't interview Miss Hightower. I only interviewed Mr. Brantley.
I thought you said the student did Hightower. Well, who talked to
Ms.
Hightower?
Stevenson must have, but I'll go on the record.
Okay.
Lakers fan P86586 on behalf of Ms. Hightower.
All right. And Ms. Hightower, unmute and state your name.
Tatanisha Hightower on behalf of myself.
Oh, on behalf of yourself. So that's probably why they put a plus sign. You didn't want a lawyer to talk to you?
Oh, no. I spoke with Ms. Stevenson just a second ago.
Oh, okay. And then what's your middle name?
Imani.
Thank you. Well, why did you say on behalf of yourself?
I don't know, Judge. I'm learning.
You nervous?
I'm learning court etiquette very much so.
Oh, okay. That's okay. Don't be nervous. They get. Oh, I almost thought. Okay. Don't be nervous. Okay, so you are accepting the representation of the defender's office. You spoke to Ms. Stevenson.
Yes.
Ms. Span's colleague. Okay, thank you. Okay, so today is the date set for an arraignment on a bench warrant. Ms. Span.
Judge, I would like to request a recall of the bench warrant. Ms. Hightower capious, but she was currently in probation status and now has a 0 balance.
No, I think that's the other person. I think that might be Riley, I think. Because Ms. Hightower, unless Ms. Stevenson got them mixed up. Ms. Hightower, I thought she's told us capious at a pretrial. Let's see.
Okay, let me look at it.
Okay.
But I would still like to recall the warrant as Ms. Hightower has appeared. She's made herself available to the court and would like to move forward with this matter.
Okay. Madam Clerk, can you just confirm for me?
Checking now, Judge.
Thank you.
Yes, Your Honor. Escape is for a pretrial.
Okay. Then the court will enter a not guilty plea on behalf of Ms. Hightower. I will set aside any capias, recall any warrant, set the matter for another pretrial conference. Court is going to set the pretrial conference for oops, I was moving too fast. All right, I'm going to set it. For Monday, August the 14th. And I'm going to set that at 8:34.
8:34.
Yes. Bond will continue. I'm assuming she posted a bond to get this court date. Ms. Hightower, did you post a bond?
I did.
How much? $10?
Yeah.
Bond will continue.
Thank you, Judge.
All right. Anything further with respect to Ms. Hightower?
Not from the people, Judge. Thank you.
No, thank you.
And I guess I should say bond will continue with, of course, a no contact condition with the complaining witness. All right. Ms. Hightower, you're all set until August 14th at 8:34 on Zoom.
Okay. Thank you.
You're welcome. Have a great day. Stay safe.
All right, you too. Bye-bye.
Ready on Brantley. This is case number 224514701. The people of the state of Michigan versus Isaiah Edward Brantley. The defendant is charged with 1 count of license plate illegal use. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. My name is Demel Isho, and I am a third-year student in good standing at an accredited law school. And I request permission to practice pursuant to Michigan Court Rule 8.120B under the supervision of the attorneys of misdemeanor and felony defenders.
Permission granted.
Thank you, Your Honor. Demel Isho appearing on behalf of Isaiah Brantley, who consents to my appearance on his behalf. Do you agree, Mr. Brantley? Brantley?
Unmute, Mr. Brantley.
Yes, you hear me fine?
Yeah, we can hear you.
Please say your name for the record, please.
Isaiah Edward Brantley.
Thank you.
Today is the day set for pretrial conference. Mr. Isho, how are we proceeding?
Your Honor, at this time, my client will continue his plea of not guilty and ask the court to set the matter for a final pretrial conference and request discovery if it was not tendered.
Court is going to continue a not guilty plea on behalf of Mr. Brantley. I will set the matter for final pretrial conference September the 14th. At 9:00 a.m. Discovery should be submitted to the defense no later than August the 14th. Bond will continue with no driving without a valid license and without valid registration. Anything further?
Judge, the people sent discovery on this case on January 18th, 2023 to Ms. Stevenson.
You did?
Yes.
Why? Okay, well, discovery has already been submitted. Final pretrial conference is September 14th. Anything further?
Nothing from the people, Judge. Thank you.
Nothing further, Your Honor. Thank you.
All right, then we're all set, Mr. Brantley, until September 14th at 9 o'clock. Have a great day. Stay safe.
I do the same. Thank you.
You're welcome. All right, are we ready on Holy or Covington? No? All right. I'm gonna head downstairs so I can do the in-person. All right. All right, are we ready on May?
Ready on May, Your Honor.
Ready on May? This is case number 02-689-9901. The people of the state of Michigan versus Alicia Danielle May. Defendant is charged with 1 count of malicious destruction of property. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson, appearing on behalf of Ms. Delisha May. Good morning, Ms. May. Ma'am, please tell the judge your full name.
Alicia Danielle May. Thank you. Today is the date set for a pretrial conference. How are we proceeding?
On behalf of Ms. May, Your Honor, we would move for dismissal for the complaining witness's failure to appear.
Ms. Ritter.
Your Honor, it's at least the second scheduling of the pretrial conference. The court required the complainant witness, Ms. Sharon Flucker, to be present. I don't see anyone in the waiting room by that name. There are 2 unidentified devices in the waiting room, Your Honor. In the event that is not the complainant witness in this matter, the people will not be able to proceed based on the complainant witness's failure to appear.
The person on the iPhone, please unmute and state your name.
Amisha Williams.
Ms. Williams, you late for court?
No, actually, I called and then they told me that I couldn't call.
No, actually, you late. Okay, what you said? I called and what?
I called and they told me that I couldn't call. I had to video, but on the paperwork, it gave me an option to call in.
I don't care about that paperwork. I told you you couldn't call in here today. I don't care nothing about that paperwork. I told you couldn't call in. I don't accept defendants who are not on video. So the paperwork doesn't mean anything to me. I'm presiding. My name is Judge Lynise Bryant. I am presiding. And I said you can't come on the telephone. That could be anybody. How could we know who's on the telephone? You wouldn't want a witness to come and testify against you, not on video, and just saying whatever they want to say. No, we need to see the people's faces. But thank you for stating your name. I appreciate it. Now please start your video.
I apologize, Your Honor.
I accept your apology. I'm going to put you in a breakout room where you can speak with the lawyers. There's going to be a prompt on your screen. Please accept to join the breakout room and wait for a lawyer to come in to speak with you.
Thank you. Have a blessed day.
Accept to join the breakout room. Today is the day set for pretrial conference. The complaining witness has failed to appear after being required to do so. The people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion and dismiss the matter without prejudice for failure of the complaining witness to appear. Since Ms. May is in person, ma'am, please have a seat on the back row and we will get you a copy of the order of dismissal for your records. Have a great day. Stay safe. I'm ready on, Ms. Houston, are you ready on Hampton?
Not yet, Your Honor.
Okay, I'm ready on Gavin.
Okay.
Why I say little? Why do people say little? The paper is the same size.
Right.
Okay, this is case number 194492801, the people of the state of Michigan versus Eddie Gavin. Defendant is charged with one count of operating while intoxicated. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And for the records, Your Honor, Janice Stevenson appearing on behalf of Mr. Eddie Gavin. Morning, Mr. Gavin. Sir, please tell the judge your full name.
Eddie Gavin Jr.
Thank you. Mr. Gavin Jr., right? All right. Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report with respect to Mr. Gavin Jr. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
So, Your Honor, just a minor correction on the face page under the original charge. There should be count one operating with a high BAC and count two operating while intoxicated. Second offense notice. The plea agreement, which is reflected correctly, states that the count one was dismissed and the second offense notice was withdrawn from count two. So that leaves us with the final charge of operating while intoxicated.
Okay, thank you. Any additions or corrections on behalf of the defense?
On behalf of Mr. Gavin, Your Honor, we've had the opportunity to review the pre-sentence investigation report. Excuse me, Your Honor. And we do find it to be factually correct with the people's correction. Other than that, we have no additions, deletions, or corrections. And actually, there is a correction on the face sheet on the social security number, and in that Mr. Gavin is in person, I would ask that he just provide that correction directly to the court. The last 4 digits are incorrect, and he'll give the court the correct 4 digits. Other than that, we have no additions, deletions, or corrections, and Mr. Gavin does stand ready for sentencing.
All right. With respect to sentencing, is there anything on behalf of the people?
No, Your Honor, thank you.
Well, I have a question for the people.
Yes, Judge.
Probation, I have the clerk looking in the file for me. Probation said they didn't have an investigation report. I have no idea of how high Mr. Gavin's blood alcohol was. Do you have I know he was charged with high BAC, but they say there's no police report.
Okay, Judge, if I can just have a moment, I can pull that back up. I accidentally exited out.
Okay, no problem. Ms. Stevenson, anything on behalf of the defense?
So, Your Honor, we just would bring to the court's attention that Mr. Gavin, pursuant to the court's bond condition, has been submitting to random screening. He has to actually do that at work, Judge. And I don't know if I have any screenings from the probation department, but as a condition of his employment, Mr. Gavin has to submit to your analysis twice a month, random. He can talk to you about how how strict they are about that. He's never had a positive test, and he's had to submit to urinalysis for over 2 years to maintain his employment. He's never had a positive test. Mr. Gavin, I believe last time he was in court, or he tried to be in court, he had some technology problems, Your Honor. He had been sitting in his car, I think, for most of the morning, but he was never able to connect. So the court ordered Mr. Gavin to be here in person today, and he's done that. I believe that that is an indication that Mr. Gavin intends to continue to abide by all court orders, put this matter behind him as swiftly as possible. And I think he's going to be a good candidate for probation, Your Honor.
Ms. Ritter, any luck?
Yes, Your Honor, I was able to locate the blood alcohol content. It was 0.18.
Okay, thank you. Mr. Gavin, would you like to make any statement on your own behalf?
No.
All right. The court has had an opportunity to review the pre-sentence report. I am ready to impose sentence. First thing I noticed, I won't say the first thing. One thing I noticed when I reviewed the pre-sentence report is that Mr. Gavin doesn't qualify for defender services. Y'all can see that? He has no dependents. I'm sorry, one dependent. And that's his rate of pay, isn't it?
I did not take note of that, Your Honor, and I haven't done any calculations, so I'm not ready to move on that yet. But of course, we're going to go with whatever the court says in terms of sentencing and reflecting that in the costs that the court would order.
Court is going to impose a sentence as follows. I will accept the recommendation from probation for a term of probation, and the recommended term of probation due to his previous history is 18 months. The court is going to accept that recommendation for an 18-month probationary period. That will place a final review date of January 10th, 2025. Of course, Mr. Gavin would be eligible for early discharge after 9 months, after he served 9 months, if he has completed the terms and conditions of probation as follows. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without the consent of this court. You must notify probation immediately of any change of your address, phone number, or employment status. And you shall pay the following fines, costs, and fees. The court is going to impose mandatory costs of $210, a $400 fine, no restitution, supervision fees at a rate of $35 per month for 18 months is $630. Of course, for 9 months is $315. $100 pre-sentence investigation and substance abuse evaluation. Fee, and the court is going to impose a $400 attorney's fee. I calculated, well, I don't want to tell people how much he made, but I calculated that he doesn't qualify.
Okay.
So he is responsible for paying a portion of an attorney's fees, a portion of an attorney's fee. I'll reduce it actually to $300. Total fines, costs, and fees for 18 months. Is $1,640. For 9 months is $1,325. Additionally, sir, you shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not consume alcohol in any way, whether it's a beverage, whether it's a cookie, whether it's a lemon drop. Now, what she tell me? A Jello shot? Nothing. You shall not drive without a valid license. According to this report, your license is suspended and your driving status is ineligible. You shall not, you shall attend and complete the alcohol highway safety education level 2. You shall submit to urinalysis twice per month. You shall view the victim's impact panel and watch the consequences video. You shall they ordered that he attend, they not ordered, oh, that was definitely the wrong word, recommended that he attend outpatient treatment. However, I'm going to indicate that he will attend outpatient treatment only if he tests positive. So I'm not going to order you to go to outpatient treatment, but if positive, then we'll look at the outpatient treatment. They also recommended 30 days of community service. I don't know why. I'm not going to honor the 30 days of community service. No, okay. I will take it down to 3 days of community service, and maybe that's what they meant. I don't know, but 3 days of community service, which is equivalent to 21 hours of community service. You shall also attend or complete, I don't think it's an attending, it's online, the driver's improvement program. According to the report, you don't have a balance with 36th District Court. However, that will be on your order, that you paid any outstanding tickets in case that was a mistake. According to the report also, you don't have any outstanding warrants that you have to clear up. I'm going to set a review date, for January the 18th of 2024. You won't be eligible for discharge on that date. That's a 6-month date. But if you're on point, if you're, if it looks like you're going to be discharged early, then I'll give you a 9-month date. Okay? And if I didn't say so, this is reporting. I think I did say it. Also, with respect to the drug test, the urinalysis, of course, so Ms. Easton, you said he's testing for his job, which is fine, and I'm assuming that we're getting those results.
That's what I'm not sure of, Judge. I thought that was happening, but I'm not sure that that is happening.
Well, I will hope that it's happening, because otherwise I should have gotten a notice of violation from probation.
Right.
Unless my order never went. Well, he's going to test twice a month. So if you haven't already done so, which I'm hoping that you have, because otherwise my system has been a complete failure. You'll have to sign a release so that your job can send the results to probation. So you don't have to test 4 times a month, because if you're testing with your job. We are going to mail a copy of this report, the order, to the Townsend Street address. Probation is going to contact you at the phone number that ends in 1382. Anything further with respect to Mr. Gavin?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Gavin. Thank you very much, Your Honor.
And Mr. Stevenson, let me just address the correction to the social security number. I have no idea why they even put that on this report. So I could care less
I
about
agree with
the
that, Your Honor.
social security number.
Okay. Thank you.
Yeah, I have no idea why they need to put that on a report.
Okay.
All right. Then Mr. Gavin, you're all set with me until January 18th at 1:30 on Zoom. So I don't remember what your Zoom issue was, but on Zoom, if you're able to Zoom in, okay?
Okay.
All right, you're all set. Have a great day, sir. Stay safe.
Thank you.
All right, Ms. Dixon, did you email the order yet?
I did. Is it Miss Selman today?
Yes.
Okay, I thought I recognized your voice. Yep, I did.
Print it. It's not long. Print. That's what I've been trying to do for the last.
Oh, well, first, before you log off, just forward it to me.
Oh.
Forward it to me. See if it'll let you forward.
If Mr. Hampton has a phone, could he go to the hallway, please, Your Honor?
Oh, why did I give you that? I'm sorry, that's mine. He went to the hallway, Miss Eason, so I'm assuming he has his phone.
Okay, thank you, Judge. Thank you.
Okay. Yes.
I just wanted to ask you a question. I don't think it had nothing to do with work.
And that's probably why she can't. What's the question?
Oh, no, that's not.
Okay. I signed the order, so we'll give a copy of the order. All right, okay, I'm coming back upstairs. I'm going back upstairs. I was just coming down to do the in-person since I was here myself. But I'm coming back upstairs. Ready on Coley? I'm assuming that Mr. Isho spoke to Ms. Williams.
That's correct.
On Coley, this is case number 214435401. The people of the state of Michigan versus DeAndre Lavelle Coley. The defendant is charged with 1 count of assault aggravated. Today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. DeAndre Coley. Mr. Coley, sir, please tell the judge your full name.
DeAndre Lavelle Coley.
Thank you. Today is a day set for final pretrial conference. How are we proceeding?
Your Honor, at this time, Mr. Coley will continue his plea of not guilty. And we're going to ask that this matter be set for jury trial.
Court is going to continue a not guilty plea on behalf of Mr. Coley and place him on the jury trial track. I will set a final pretrial conference. Yes.
If I may, I'm sorry to interrupt, Judge, but my notes reflect that there was a pretrial conference on April 14th. The complaining witness did appear. However, according to my notes, the complaining witness was at work and she was removed from the court. So the court adjourned this matter to July 13th today, and the complaining witness was required to appear.
What was the complainant's name? What is the complainant's name?
Jordan Smith.
Ms. Stevenson?
Is there one complainant or are there multiple complainants?
There's 1 count.
In that case, I have notes that are consistent with Ms. Ritter's statement, but my notes said first complainant. So if the people are not ready to proceed pursuant to a court's order of the complainant's presence, we would move for dismissal.
How can it be more than 1 complainant if it's only 1 count?
I agree with the court. But I know what I wrote. So just as an officer of the court, I make that representation. But if the people are not ready to proceed based upon the court's order, which absolutely trumps my notes, I would move for dismissal.
So Judge, I have it's 1 complainant. I'm looking at the investigator's report. So per the people's notes, I don't see Ms. Smith in the waiting room, Your Honor. And I don't have an explanation as to why Ms. Smith is not present. She was aware of the last pretrial conference that she was required to appear for a second pretrial conference due to the fact that she was working while trying to attend Zoom. So at this time, Your Honor, the people will not be able to proceed based on the complaining witness's failure to appear.
All right, the court is going to grant defense counsel's motion and dismiss the matter without prejudice. Sir, we will mail you a copy of the order of dismissal for your records. Have a great day. Stay safe.
Thank you. I appreciate you.
No problem. You're welcome.
Thank you very much, Ms. Ritter. Thank you, Judge.
You're welcome. Ready on Covington. This is case number 214409201, the people of the state of Michigan versus Shalana Covington. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Shalonda Covington. Ms. Covington, ma'am, please unmute and tell the judge your full name.
Shalonda Covington.
Are you all putting a D in her name? Oh, yes. Miss Silman, can you look and see if there's there's a D in her name on the file?
Let's double check. Okay.
Today is the day set for final pretrial conference. How are we proceeding?
Your Honor, Ms. Covington will continue her plea of not guilty. We are asking that this matter be set for waiver trial.
Court is going to continue a not guilty plea on behalf of Ms. Covington. Set the matter. On the trial track with respect to the trial, Ms. Covington, your lawyer, by her words, has indicated that you want to give up your right to a jury trial and have the matter heard by this court. Is that what you want to do?
Yes, ma'am.
Do you understand that if I accept a waiver from you today, that I would be the only decision maker? You would not have a jury to hear your case?
Yes.
Has anyone threatened you in any way or promised you anything to get you to give up your right to a jury?
No, ma'am.
Any objection from the people?
No objection, Judge.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, court accepts the waiver. Having accepted the waiver, the court's next available waiver trial date is Thursday, October 5th, or Ms. Eason, that's my last waiver trial date for the year.
Okay.
October 5th.
Wow. Okay.
Yeah. I mean, unless we do like a Friday morning, but other than that, that's it. All right, so the court is going to set the waiver trial for Ms. Covington. Thursday, October 5th, there will be a 12 noon check-in.
Okay.
When is the last time the complaining witness appeared?
Judge, my notes reflect that the complaining witness appeared on April 13th of this year.
All right, 12 noon check-in. And then if the matter proceeds to trial, if everyone checks in and the people are ready to proceed and defense is ready to proceed, then it will go in person at 1:30. Anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Ms. Covington. Thank you, Your Honor.
Ms. Covington, you're all set until October 5th.
Thank you.
You're welcome. Have a great day. Stay safe.
You too.
Thank you.
Your Honor, the D is not there, but I will put it in there when I update her file.
Well, it depends. Is it because, did you look at the complaint from the prosecutor's office?
I'll I looked at the detention sheet, but let me look at
the complaint, see if whose error it is. Ms. Ritter might have to submit a new,
okay, the complaint does not have the D.
okay, so y'all messed up her name, Ms. Ritter.
It was a technical error, Judge. We can fix that.
Yeah, fix it. Fix it so we can update our system.
Okay, then I'll send an amended complaint to Ms. Seelman.
Yes.
Okay.
So go ahead and change it, Ms. Seelman. She'll send them in a complaint. Ready on, oh, I don't see Houston anymore. I'm
He's
ready.
still in breakout.
Okay. Ready on White. And then I guess I got to go back. Who are these people? Let's see. Oh, ready on White and Riley. Oh, I let in Mr. Gomez. Did I? I didn't highlight his name though. Let's see. Gomez, Williams, Alicia Williams. All right.
Judge, I'm ready on Riley and Gomez.
Okay. So I'm gonna do Riley, Houston, White, and then Gomez and Williams.
Not Houston, right?
Oh, not Houston. But I mean, if y'all get it ready. But Riley, White, and then Gomez. And Williams.
Okay.
Start your video, please. This is case number 164441801, the people of the state of Michigan versus Censor. Middle name, Lancetri, could be cut off. Riley, the defendant is charged with 1 count of malicious destruction of property. Today is the date set for an arraignment on a bench warrant where Miss Riley, I believe KP is at a review. Appearances, please. Miss
Malaki Span, P86586, on behalf of Miss Riley. Miss Riley, can you unmute? State your full name for the record, please.
Censor Riley.
Your full name for the record, please.
Oh, Censor Lantrice Riley.
Thank you. Today is the date set for an arraignment on a bench warrant. I understand Miss Riley, KP is at a review. I did mean to ask for the register of action, and I did not.
Yes, Judge, she did. KP is at a review.
Well, let me pull it up. What were the terms and conditions of her probation? Do you have it pulled up? I'm going to pull it up if you do.
No, I don't have the terms pulled up. But I know all of the cost has been paid based on the garnishment of Mrs. Riley's taxes.
All right. Miss Riley was Ms. Riley entered into a plea of guilty August 8th, 2018. She was given credit for time served in lieu of a fine. She was placed on a non-reporting probation. She was ordered to pay $1,000 in restitution plus costs. She was given 90 days in jail. Her probation was for 3 months. But apparently she didn't pay in the 3 months. Nonetheless, let's see here. September 28, 2021, the 36th District Court filed a writ for tax garnishment, and they received payment from that tax garnishment. And now her balance is zero according to the Register of Action, because she also had mailed in a restitution check back in 2018. The court is satisfied that all of the terms and conditions have been met. I am going to close the matter out with improvement.
Thank you, Judge.
Thank you.
You're welcome. Anything further?
No, Judge.
All right, then we're all set, ma'am. Have a great day. Stay safe.
Thank you. Will I have something mailed to me saying that it's closed out?
Yes.
Thank you.
I don't know that, Miss Van. What they gonna mail her? Oh, this was probation. You're right. She will. She should get a discharge.
Thank you, Judge. You had me second guess that.
Well, I was thinking it wasn't a probation, but he did put her on probation for 3 months. So she will get a closure from the probation. So, all right. Yes, ma'am. We'll mail you a discharge order. I'm assuming that you still live at the same address for that. We have an updated address for you.
I just recently updated it.
Okay. Then
You
you're all
provided
set.
that information. Yes.
Have a great day. Stay safe.
Thank you. Y'all as well.
You're welcome. Thank you.
Bye-bye.
All right. Ready on White. This is case number SX 45103-431. The people, is this supposed to be my case? Okay, the people versus Micaiah Detrice White. Defendant charged with CCW under the influence. I thought the SX cases went to the general ordinance docket. Today is the day set for final pretrial. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. And I think they do go to the traffic docket.
I think so too. Ms. Stevenson, appearance, please.
Janice Stevenson appearing on behalf of Micaiah White. Ms. White, ma'am, please tell the judge your full name.
Micaiah Detrice White.
Thank you. So, Ms. Stevenson, what were you going to do today with respect to this?
I was going to ask that this get a final pretrial conference so that we could get the misdemeanor dismissed and get a civil infraction issued, which would send it back over to that docket anyway. I think.
What? What are you saying? Oh, I did it. Okay. Good morning. I was trying to reach Mr. Navy. Okay, this is not on my docket properly, and I don't know why we didn't catch it before, but nonetheless, it's going to go to Judge Marlena Taylor. Ms. Silman, can you call Judge Taylor and get a court date?
Yes, Judge.
For another final pretrial conference, Ms. Stevenson. Of course, that will be House Counsel. So I don't know, but I think Judge Taylor has a regular prosecutor if somebody wants to notate the file of or you know, I don't know if she has like a regular House Counsel person, but somebody can notate that. But these cases are not supposed to come to me. It's supposed to go on the General Traffic and Ordinance docket. So, Ms. White, I'm going to give you a new court date, but the case is being transferred to Judge Marlena Taylor. And I'm also going to give you her Zoom ID number once I get the court date, okay?
Okay, thank you.
You're welcome.
Okay, Judge, they said September the 6th at 8:30.
September 6th at 8:30. What's Judge Taylor's courtroom number?
It is 337.
So, Miss White, how did you log into my courtroom today? Did you type in the Zoom ID number?
Well, no, I just, I go to 36th District Court. I put my name in and then I kind of just,
okay.
I remember you.
So you can do that again. And it should the next time, I don't know how that works, but anyway, you click on Judge Marlena Taylor. That's going to be your judge. So
Marlena Taylor.
Marlena Taylor. September 6th. Did you say 6? She said 6.
Yes.
Mm-hmm. All right. September 6th at 8:30.
8:30.
Marlena Taylor is going to be your judge. You're going to have a different lawyer because they have House Counsel that services her courtroom. But talk to the lawyer about getting it reduced to a civil infraction. That's what Ms. Stevenson's intentions were. Okay.
Okay. Thank you.
All right. You're welcome. You have a great day and stay safe.
You have a blessed one. Thank you.
Thank you.
Bye-bye.
Bye-bye. All right. I'm ready on. And then remind me, I have to send him an email, but I can't do it right now. On that case. Okay. I'm ready on. Let's go back up. Gomez. I'm ready on Gomez, Williams, Hampton, Houston. This is case number 206055501, the people of the state of Michigan versus Miguel Gomez. Defendant is charged with one count. Defendant is charged with one count of reckless driving. Today is the date set for an arraignment on a bench warrant. Appearances, please.
Malika Span on behalf. Oh, go ahead, Ms. Ritter.
I'm sorry. For the record, Your Honor, Christina Ritter on behalf of the people.
Malika Span on behalf of defendant Mr. Gomez. Mr. Gomez, can you state your full name for the record, please?
Yes, it's Miguel Ramon Gomez.
Thank you. Today is the day set for an arraignment on a bench warrant. I understand that Mr. Gomez is at a final pretrial conference. Ms. Span, how are we proceeding?
Judge, I would like to request a recall on the bench warrants. Mr. Gomez has made contact with the court and posted a bond and appeared today. And with that recall, maintain his guilty plea and request a final pretrial date.
Not guilty, you meant?
Not guilty. Yes, not guilty.
I knew that's what you meant. Court is going to set aside any KPS, recall any warrant, enter or continue a not guilty plea. On behalf of Mr. Gomez, I will set this matter for another final pretrial conference, September the 14th at 9:04. I don't know why Mr. Gomez missed his last final pretrial conference, but if he misses this next final pretrial conference, his bond is going to be higher than it was. The bond will continue that he posted. Anything further?
Yes,
No,
Judge.
thank you.
Oh, Ms. Ritter.
So, Judge, I'm looking at my notes, and it looks like Mr. Gomez pled.
He already pled?
On the reckless driving on March 31st, or no. His sentencing date was March 31st, 2021, according to my system.
All right, hold on. Let me look.
Yes, ma'am. If I could say, I think I did had pled the last time I went to court.
Hold on,
Mr.
sir.
Gomez.
Please. Thank you. Tell me, is Ms. Stevenson back on the screen yet?
No.
No.
I'm gonna tell Ms. Stevenson her notes we might not be able to rely on her notes. All right, Gomez, let's see. He was scheduled for final pretrial conference back in June. And then he failed to appear. Then it was scheduled in August. That was 21. Oh, I'm way too. Okay. And then the reason Ms. Stevenson was confused is because this register of action is not updated. This is not acceptable. Okay, let's see. Okay. What date do you have, Ms. Ritter, that the defendant appeared?
That he appeared?
Yeah, you said he pled guilty. What date? Or what date was his sentencing supposedly?
My system says March 31st, 2021 was the date of sentence.
Oh, 2021?
Yes, Judge.
Oh, hold on. 2021, let me go back. All right, so. Started out as a felony. Proceeding held, dismiss. He pled at the felony level. He did right there. Pled at the felony level, scheduled for sentencing March 31st. So the error occurred and he was sentenced by me. All right. He was sentenced. So this is incorrect. Ms. Stevenson was incorrect. However, I see why she said what she said.
Yeah.
So on June 21st, when he failed to appear, we set it for June 30th. This is all in 2021. The clerk at the time scheduled this for the wrong thing. I don't know why they did that, but they scheduled it for a final pretrial. That is incorrect. That is incorrect. All right. So he did not capious from a final pretrial. He capious from his review. And his probation officer is Mr. Schiotti. So the court is going to strike the date that I gave. Well, I won't strike the date, but we're going to change it from a final pretrial conference to a review. We're going to schedule it for 10:04. 10:04. We're going to make sure that, so I'm going to send Mr. Gomez back to the breakout room, and I need you all to give Mr. Gomez Mr. Schiotti's contact information. I guess Ms. Stevenson has it. I don't know Mr. Schiotti's direct number, but we're going to give Mr. Gomez Mr. Schiotti's information. Then we're going to make sure Mr. Schiotti has Mr. Gomez's information. This should be a review, not a final pretrial conference.
Okay. And the date remains September 14th?
Yes.
Changed? Okay.
Yes, the date remains September 14th.
Excuse me, ma'am.
Can you send me Mr. Schiotti's information, please?
You all were talking at the same time.
Sorry.
Ms. Spann, what did you say?
I was asking the clerk if she could share Mr. Schiotti's information with me.
All right. Mr. Gomez, ask your question in the breakout room to the attorney, and then they'll see if it's appropriate for you to ask it to me. I'm going to move you. You used to be in breakout room number 10. I'm going to move you to breakout room number 8.
Okay.
The prompt should come up on your screen.
Okay. Thank you.
You're welcome. All right. Mr. Isho, who were you ready on?
Miss Williams.
Okay. I'm going to do Miss Williams, and then Miss Spann, you can go into that breakout room with Mr. Gomez, and then I don't know if you are ready on, I think Miss Stevenson might want to do Miss Terry.
Miss Stevenson is doing it, Miss Terry. I was just waiting on the clerk to message me before I left.
Okay, so let's do Miss Williams while you're here so that the student can be supervised. This is case number 154503401, the people of the state of Michigan versus Kamisha. It may be LaShawn Williams. Defendant is charged with 1 count of operating with a high BAC. Today is the date set for an arraignment. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Demel Isho on behalf of Kamisha Williams, who consents to my appearance on her behalf. Is that correct, Ms. Williams?
Unmute, ma'am, if you're talking. I can't hear you.
Yes.
Please state your full name for the court, please.
Kamisha Lachey Williams.
Thank you.
Today is the day set for an arraignment. Mr. Isho, how are you proceeding?
Your Honor, we waive the reading of the complaint. My client stands mute and asks that a not guilty plea be entered on her behalf, and we request the matter for a pretrial conference.
Court will enter a not guilty plea on behalf of Ms. Williams. I will set the matter for pretrial conference.
We also ask that—
Hold on, counsel. Pretrial conference, October the 12th at 8:25. Discovery should be submitted by September the 12th. And then ask to bond, Mr. Isho.
Oh, yes, Your Honor. We ask that the June 5th bond be continued. Ms. Williams has contacted the court today to set up her court appointment. She has good contact information, and she has not missed any other court dates. This is her first arraignment.
So if it's her first arraignment, how did she post a bond on June? What date did you say?
June 5th. I think this was a previous bond that she had posted.
Madam Clerk, do you have a bond in the system for Ms. Williams?
Checking out. Yes, Judge, from June 5th, $100.
All right, Ms. Ritter asked to bond.
Judge, the people have no objection to a personal bond. However, due to the nature of the charge.
$100 bond, $100 bond.
I'm sorry. The people have no objection to continuing the $100 bond. However, Your Honor, due to the nature of the charge, we are asking for random urinalysis testing at least twice a month.
Court is going to continue the bond that was posted. However, as a condition of bond, Ms. Williams must submit the urinalysis at least twice per month. No. I haven't even gone on the record with Hampton yet. That's presumptuous. No, I won't.
Okay, Judge, I'm sorry. I thought you had already spoken.
No, I have not gone on the record with Hampton. That's something between you and Ms. Stevenson that it don't have nothing to do with me. As to the, Ms. Williams, the court is going to order your analysis twice per month. As a condition of bond, you must submit to your analysis twice per month. You must submit on the day that they call you to go. You cannot go on a different day. Whatever day they say show up, you must show up that day. That day. All right, anything further?
No, thank you, Judge.
Nothing further, Your Honor. Thank you.
All right.
Excuse me. I live in a different state, so I'm trying.
Well, first of all, that's a violation. And sometimes people shouldn't say stuff, but that's something that everybody should know when they come out. So I don't know what you all discussed in the breakout room, but the person living in a different state other than the state that I'm in is important information for this record every day. Number two, I don't care where she lives, and always has to be a request for permission to remain out of state, because the court could order Ms. Williams to come in state. So we're gonna send Ms. Williams back to the breakout room. I don't care where Ms. Williams lives. My order is my order, but somebody needs to ask me for permission for her to live where she's living. All right, so we're gonna send Ms. Williams back to the breakout room. She was in breakout room number, I don't see her name, hold on. She was in 4, I'm gonna move her to number 1. All right. So I guess if you want Mr. Isho to go back, I didn't see where Mr. Isho was in there. Oh yeah, I do see him. You can move Mr. Isho to 1 though. And then Ms. Spain, you're all set to go in that other breakout room.
Okay, thank you, Judge.
You're welcome. I'm ready on Terry and then Carrington, and then it looks like we're ready on Hampton.
Correct, Your Honor.
This is, oh wait, I gotta pull up Miss Terry. I have printed it. Hold on. Yes, this is case number. This doesn't tell me anything about the case number or nothing. Does anybody know Miss Terry's case number? So I don't.
Ms. Terry has more than one case.
For this tether violation. Oh, I see the case number right here, but it does tell me. Oh, yes, it does. I think Ms. Terry is here on case number 21455-5001. The people of the state of Michigan versus Khadijah Terry. Defendant is, I believe, charged with one count of malicious destruction of personal property. So let's look that up and confirm. I'm reading that strictly from the tether violation notice. And then today, Ms. Terry has been brought before the court for a tether violation. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Khadijah Terry. Ms. Terry, ma'am, please unmute and tell the judge your full name.
Where's the mute button at? Can you hear me?
Yes,
yeah.
ma'am. State your name.
Khadijah Terry.
All right. Does Ms. Terry have any adjudicated cases?
So she's scheduled for sentencing on the several matters before this court, and I was actually going to say something about that.
When is she scheduled for sentencing?
That's what I need to see.
Tomorrow.
Is it tomorrow? Okay.
Okay, well, maybe we need to sentence Ms. Terry today.
Well, yeah, that's what I was trying to do, but I looked at the PSI and I don't know that they did the PSI interview.
Well, but what is she charged with?
She has
retail fraud and stuff.
Yeah, retail fraud, I think, and malicious destruction of personal property.
Well, let me just tell you, I'm reading the tether violation, and I mean, clearly I'm probably going to send her to mental health treatment court.
Yeah, I think that's what we've been trying to do is get her over to the specialty court, once her case has got adjudicated. Right. So
because she's trying to go back to Naomi's Nest, but I mean, I don't know if Naomi's Nest is going to take her back since she absconded it from the hospital, but I'll leave that up to Judge Holmes because they can find other places for Ms. Terry to go to if Naomi's Nest says no.
Okay.
So let's do this. While we have her here.
Okay.
Let's, Madam Clerk, see if someone from mental health treatment court can log in and talk to Ms. Terry. I'll still keep her sentencing actually on for tomorrow. See, because we can discharge her from the jail to if mental health treatment court says that they can take her, I'll have her discharged to a place. If they say she could go back to Naomi's Nest, I can discharge her to a place. I can still do her sentencing tomorrow from that place. If they have a bed for her, they'll bring her on screen tomorrow for sentencing.
Okay.
Otherwise, I mean, we could try to do it today, but I don't know. It's
okay.
I'll just see how it goes.
Okay. All right.
Ms. Terry, tell the people that you wanted to go back to Naomi's Nest?
Yes.
Okay. That's what I'm gonna try to do, but I want to transfer you to Judge Holmes. Have you ever dealt with Judge Holmes before?
Yeah, but then she said that I wasn't eligible for mental health court.
She said you weren't eligible?
Yes.
Why?
I don't know why.
Okay, I'm gonna find out today then. Did I already send you to her before? Did I send you to Judge Holmes? Okay, well, let me find out. Let me find out why.
Do you have the PSI, Judge?
I don't know. I don't pull them up until tonight. Let me see.
Okay.
I can look. I'll see if I have it.
Okay.
Ms. Stevenson, I have it.
Yeah. I'm wondering if the 2003, 11, and 12 cases are what might be keeping her out, but I don't know.
Yeah, I do have it. You said you wonder if it's what cases?
The 2003, 2011, 2012. I don't know if those are.
No, that wouldn't keep her out.
Okay. Well, I don't see anything else that.
No, but I'll ask.
Okay.
So hold tight, Miss Terry. We're going to see if they can log in, okay?
Okay.
And then I'll find out why. If they did say you couldn't come, I'll find out why, what the issue is. So give me a minute. All right, I'm ready on Carrington. This is case number 204576301, the people of the state of Michigan versus Ricky Carrington. Defendant is charged with 1 count of breaking and entering without owner's permission. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Ricky Carrington. Mr. Carrington, sir, when you're able to do so, please unmute and tell the judge your full name.
I mean, can somebody, oh, oops, we did it at the same time. Tell them to do that again.
Ricky Carrington.
Thank you. Today is the date set for final pretrial conference. How are we proceeding?
Your Honor, Mr. Carrington and I have had the opportunity to discuss this matter, and he's had the opportunity to review with me an advice of rights form. It is my understanding that at this time, Mr. Carrington wishes to waive his rights instant a trial and offer the court a plea of guilty to 1 count of entering without owner's permission.
Mr. Carrington, your lawyer has indicated that you want to give up your right to a trial and enter a plea today. Is that what you want to do?
Yes.
Mr. Carrington, I'm going to share my screen. When I share my screen, on it, you're going to see an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes.
All right. And when you did that, Mr. Carrington, did you understand your constitutional rights?
Yes.
Mr. Carrington, do you understand that this is a misdemeanor and therefore you have a right to a trial? As stated in number 2, you have a right to a trial. But if I accept a plea from you today, you will be giving up your right to a trial as stated in number 6. Do you understand that?
Yes.
Sir, has anyone threatened you in any way or promised you anything that wasn't placed on this record to get you to enter into this plea today?
No.
Are you currently on probation or parole?
No.
Finally, Mr. Carrington, I'm going to draw your attention to number 11. It indicates that an appeal to the circuit court may be taken within 21 days, however, of the date of your sentencing. However, do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal, and if you were to change your mind about the plea, you would have to request this court to set aside your guilty plea or request permission of the circuit court to appeal the conviction.
Yes.
With that understanding, do you still want to give up your rights and enter into a plea?
Yes.
Raise your right hand for me, Mr. Carrington. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You may put your hand down. Ms. Stevenson?
Thank you, Your Honor. Mr. Carrington, on October 19th of 2020, were you present at 15363 Livernois in the city of Detroit?
Yes.
And did you enter into a building at that location without the permission of the owner, Leah husband?
Yes.
Thank you. And with that, Your Honor, defense is satisfied.
Are the people satisfied?
The people are satisfied, Judge.
Court is satisfied. I will accept a guilty plea to one count of breaking and entering without owner's permission. Having accepted that plea, I do have to set the matter for sentencing, but Mr. Carrington appears to be in custody. And I'm assuming he's not in custody for this. Am I correct?
Correct, Your Honor.
And I'm assuming that you're probably trying to ask me for credit for time served. Am I correct?
I am. You are correct, Your Honor.
So this is what I have to do, because notwithstanding your request, notwithstanding that there's probably not going to be an objection from the people, but I don't know. I do have to set the matter for sentencing, give the victim an opportunity to make a victim impact statement. I would set the matter for sentencing. Let me see if I can fit it in August. Is Mr. Carrington under sentence for another matter, or is he just being held on bond?
Mr. Carrington?
I have a closed case.
What does that mean?
I have time served. I'm getting time served and my case is closed.
Oh, on another case?
Yeah.
So is this case what's holding you up?
Yes.
Oh, let me verify that with the deputy, because where's the deputy?
Excuse me.
If that's the case, I want to try to squeeze him in for real. Hi, deputy.
How you doing, ma'am?
Mr. Carrington says on his other case, he's already been sentenced to time served, and that this case is what's now keeping him in the Wayne County Jail. Are you able to verify that for me?
Yes, ma'am. I can look it up.
Oh, no. What you say, Mr. Carrington?
What I mean is I have an out date on the 30th.
Oh, okay. Thank you. So you got time served, but your out date is July 30th?
Yes.
Okay. Okay. All right. Thank you. Okay. So never mind, deputy.
No problem.
Okay. So then that being the case, let's see if we can get Mr. Carrington sentenced on July 27th.
Okay.
So I'm going to put him on for July 27th at 9 o'clock. No, 8:59, no PSIR. July 27th at 8:59. Okay, Mr. Carrington, so I'm gonna I'll get your sentence before your other case, okay?
All right, thank you.
All right, you're welcome. I mean, before your out date. All right, have a great day, stay safe.
All right, thank you.
You're welcome. I was just getting ready to ask, and they popped right in. They popped in as soon as I was getting ready to ask. As soon as. I like that timing. All right. Whoops. Miss Taylor, you can start your camera.
Thank you. Good morning, Judge.
Good morning. Miss Taylor, I'm sending you Miss Khadijah Terry.
Yeah, Judge,
She
know,
said
we've
y'all
had her
already
before.
that's what she said. Y'all don't want her, or y'all said she's
Right, she's not eligible.
why? What she...
I don't know if you want to put it on the record, but due
Oh,
to her,
let's go to the breakout then.
okay.
All right.
May I come, Judge?
Yes.
Thank you.
We're gonna go to number 15.
Me too, Judge.
Yes.
them. I ain't going to October 12th. Oh my God. Mm, mm, mm. She mean as ever to me. Ooh, so nice to that man. Lord, nobody said this.
Miss Terry, unmute. You unmute? Hold on, Miss Terry. Let me see. Oh, the jail might have to come and unmute you. Let's see. Does it show up? Oh, what's going on with Mr. Houston? Is Mr. Houston ready? Because there's no plus sign.
He's not. I need Mr. Houston to go back to his breakout room and this time be on video and audio.
Okay, you wasting our time. She needs you to go back to the breakout room so somebody can come in there and talk to you. You're wasting our time. And in a minute, court is going to be over and you're just going to be sitting in there by yourself. Let me move him. Miss Terry, I have a question. So you are correct, and I know you knew you were correct. But have you had any contact with a guardian? Have you had any contact with a guardian at all?
No.
Okay. And were you aware that you still have a guardian?
No, I was aware that I had a guardian, but it had expired. The paperwork had terminated.
Oh, not according to what we looked up. But we're gonna figure it out, Miss Terry. So this is what I'm gonna do. You're scheduled to be sentenced tomorrow. I'm gonna contact Naomi's Nest, and I'm gonna see, since you're not eligible for the specialty court, I'm going to see if Naomi's Nest is open to having you coming back. And then if not, I'm going to have to figure out some other place that I can try to have you go. So give me a day. I need a day, Miss Terry. So you're going to have to stay put. I need a day to figure it out since you're not eligible for the specialty court. So they're going to bring you back on screen tomorrow. And number one, we're going to try to confirm whether or not the guardianship has been terminated. Because if it has not been terminated, we may be able to contact the guardian to see if we can even get you in another facility based on the guardianship, like something else if Naomi's Nest can't take you. But I'm just trying to consider all the options, okay?
Okay.
All right, so I'll see you tomorrow back on screen, okay?
Okay.
All right.
Judge, could I'm thinking about this as it's going. So I am I'm assuming that however the court does dispose of this case, that there'll still be a GPS tether.
I don't know. No, I don't know.
Okay. Well, that's 100%. Okay, never mind then at that. I was going to say, you're going to put her on a tether. If we could go ahead and just order the tether and tethered her back to Naomi's Nest, then the jail could start doing the legwork on that. If Naomi's Nest if she's not eligible to go over there, then we'll know that sooner rather than later.
I mean, I could go ahead and say bond continue with the tether in case I do, but I'm not guaranteeing you that I will, but that will put her in line for the tether.
Mm-hmm.
So if I say a tether, but so I'll go ahead and say bond continue with the tether, that'll put her in line, but I may take that tether off tomorrow depending on what happens and depending on if she does have a guardian and we're, depending on if we can send her somewhere.
Okay.
Because you also got to remember the jail, the county
mm-hmm.
is not in favor necessarily of post-sentence tethers.
Oh.
Post-sentence tethers, the defendants have to pay for.
I don't think I knew that. Okay.
Yeah. So I'm going to figure that out.
Okay.
All right, Miss Terry, I'll see you tomorrow.
Okay, thank you.
All right, bye-bye.
Bye.
Okay. Mr. Isho?
Yes, Your Honor.
All right. Is there anything? Oh, yeah, we're still addressing Ms. Williams. So we're back on the record with case number 154503401, Kamisha Williams. So, Mr. Isho, where does Ms. Williams live? As she told me, she does not live in the state of Michigan.
Yeah, she lives in Ohio, at 5600 West.
Oh, no.
Sorry.
Don't give her address on the record. We're live on YouTube.
Thank you.
Sorry about that.
All right. So she lives in Ohio.
Ohio,
yeah.
And the reason
at the time of this alleged offense, was she living in Ohio?
I believe so.
No, she said no.
No.
So she left the state after, the allegations, but today is the date set for her arraignment. So she lives in Ohio. We're going to get that address to the clerk. You can, I will allow her to remain in Ohio, but let me be clear about my order. It costs $20 to test in the state of Michigan. At the most that we charge people is around $20. It costs $10 to test at the 36th District Court. If it costs $150 to test in Ohio, I don't care. So if she's going to test twice a month, if she's living in Ohio, that's her choice and that's her business. I'm going to allow her to remain in Ohio. But if Ohio charges $150 per test, my order is the same. She's going to submit to urinalysis twice a month. We will notify probation of her address and of my permission that she can test in Ohio. But it is a condition of bond. It is a violation of the bond to fail to test. If she can't afford to test in Ohio, then she needs to come to Michigan and test in Michigan. But let me just be clear, cost of the test is not going to stop the requirement for the test. Ms. Williams has permission to remain in the state of Ohio. You cannot leave the state of Ohio without the consent of this court. You cannot leave the state of Ohio without the consent of this court. Anything further?
No, thank you, Judge.
That's everything, Judge. Thank you.
All right, we're all set until October the 12th at 8:25 on Zoom, ma'am. Have a great day and stay safe.
Thank you, Your Honor. I appreciate it.
No problem. All right, let's make sure that my referral to probation for the testing says all of that stuff. Okay. Ms. Stevenson, are we ready on Hampton?
Ready on Mr. Hampton, Your Honor.
I'm ready on Hampton. This is case number 235502101. The people of the state of Michigan versus Savante Maurice Hampton. Defendant is charged with 1 count of reckless driving, 1 count of driving while license suspended, revoked, denied. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Savante Hampton. Mr. Hampton, sir, please tell the judge your full name.
Savante Maurice Hampton.
Thank you. Today is the day set for final pretrial conference. How are we proceeding?
Your Honor, Mr. Hampton and I have had the opportunity to discuss this matter, and he's had the opportunity to review with me an advice of rights form. It is my understanding that at this time, he does wish to waive those rights incident to trial and avail himself of an offer from the people, offer the court a plea of guilty as charged to count 2. And we believe that the peoples would agree to dismiss count 1 pursuant to that plea agreement, Your Honor.
Ms. Ritter?
Your Honor, that is correct. That is the people's offer at this time, and that's correct too.
Mr. Hampton, your lawyer indicates you want to enter a plea today to driving while license suspended, revoked, denied, second offense notice. Is that what you want to do?
Yes, Your Honor.
Sir, I'm going to share my screen. On my screen is going to be an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, Your Honor.
When you did that, did you understand your constitutional rights?
Yes, Your Honor.
You understand that this is a misdemeanor and therefore you have a right to a trial. However, if I accept a plea from you today, you will be giving up your right to a trial as stated in number 6.
Yes, Your Honor.
Has anyone threatened you in any way or promised you anything that was not placed on this record to get you to enter into a plea today?
No.
Are you currently on probation or parole?
No, Your Honor.
Finally, the court draws your attention to number 11. It indicates that an appeal may be taken within 21 days of your sentencing. However, do you understand that by entering into this plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to request permission of the circuit court to appeal or request this court to set aside the plea. Do you understand?
Yes, Your Honor.
With that understanding, do you still want to enter into a plea?
Yes.
Raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. Ms. Stevenson.
Thank you, Your Honor. Mr. Hampton, on December 29th of 2022, were you operating a motor vehicle in the area of the Southfield Freeway at McNichols in the city of Detroit?
Yes.
Thank you, sir. And was your driver's license suspended at that time?
Yes, ma'am.
Thank you. And had you previously been convicted of driving with a suspended license?
Yes, ma'am.
Thank you. With that, Your Honor, defense is satisfied.
Are the people satisfied?
The people are satisfied, Judge.
The court is satisfied. I will accept a guilty plea to one count of driving while license suspended, revoked, or denied second offense notice. Having accepted the plea, the court is ready to impose sentence. Is there any objection to immediate sentencing?
No objections, Judge.
None on behalf of Mr. Hampton. Thank you, Your Honor.
Anything from the people with respect to sentencing?
With respect to sentencing, Judge, we'll leave it in the court's discretion.
Anything from defense with respect to sentencing?
Nothing at this time, Your Honor. Thank you.
Mr. Hampton, would you like to address the court before sentencing?
I just want you guys to know that I did go get my license, so I will not be out here causing trouble on the roadways any further.
That's great. All right, the court is ready to impose sentence, and I do so in the following manner. Court is going to impose mandatory cost of $185, a $25 attorney's fee, a $250 fine. Total fines, costs, fees are $460. Mr. Hampton, how long do you need to make the payment?
About 60 days, if not a problem.
Court is going to set the matter on its docket It will be on the court's docket for September the 21st. However, the payment is due September the 14th. So pay by September 14th. It will be on the docket for review September 21st at 9:45 a.m. You do not have to come on that day or log into Zoom on that day, as long as you have paid by the 14th. If you've paid by the 14th, it will populate the system. Your balance will be zero. We will close the case out. If you have not paid by the 14th, you have to log into court or come to court on September 21st. You understand?
Yes, ma'am.
All right. Anything further with respect to Mr. Hampton?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Hampton. Thank you, Your Honor.
Mr. Hampton, you're all set, except you can have a seat on the back row, and I will sign the dismissal for count 2. All right.
Okay. Thank you.
You're welcome.
Did I do it wrong, Judge? It should be for count 1.
Oh, I mean, and you did. You did.
Okay.
You did it wrong.
I sure did. I'll fix it right now.
Okay. That's because you doing stuff too early.
I'm trying to keep up with Miss Silman because, you know, she can get kind of fierce. So. One. While that's going, I go talk to Mr. Houston, Your Honor.
Ms. Stevenson, can you tell me what your notes, can you email me what your notes say about Miss Hicks? Did you find something on Miss Hicks or no?
Miss Hicks was retained or appointed at the time, so I didn't take any notes on that last hearing.
No problem, thank you.
Mm-hmm.
You can go talk to whoever you just asked me about. I'm getting ready to bring in those other people too.
Okay, thank you, Your Honor.
You're welcome. Can I get a Ms. Ritter, do you have Ms. Hicks pulled up by any chance? Did you have any information on Hicks? I need to see what date she was here so I could pull up look at my notes.
I can pull it up, Judge.
Ma'am, unmute and state your name. Ms. Johnson.
Yes, ma'am.
State your name.
My name is Shanora Johnson.
Thank you. Mr. Norman, state your name.
Noron Norman.
Thank you. Can you both start your videos, please? Ms. Johnson, start your video, please. I'm going to send you each to a breakout room. Please accept to join the breakout room and wait for the lawyers to come in to speak with you. Ms. Johnson, please accept to join breakout room number 3. Mr. Norman, accept to join breakout room number 4. Ms. Ritter, what date did I do that?
June 29th.
All right, thank you.
You're welcome.
Yeah.
Miss,
Well, she didn't say it like that.
Miss Ritter. Miss Ritter.
Yes, Judge.
Let's go to the breakout room, please.
Okay.
I'll join you in number 20.
Okay.
Okay. Ms. Ritter?
Yes, Judge.
Do you have Ms. Hicks's case number? What was her? I don't remember her charge. The cases she pulled up, it didn't sound like my charges.
Back up, Judge. It was a felony case that was being sentenced.
A felony. Oh, I see. Is it larceny in the bill? No, that's closed.
No, the larceny. No.
I see it. I see it right here. It's a felony case. Is it? I got it. Controlled substance use, and it's a Judge Bryant. Your case.
Yes.
Reduced.
Yes. Yes. Okay. That's it. Okay. All right.
So let me get this straight, Judge. I want to.
Whew. All right. Well, hopefully she'll be able to get there today. They're going to try to get her there today. All right. Hello? Yeah, you call my office. You want me to be more. Okay. What do we have left? Let's see.
Your Honor, I have a question on.
Yes.
On the Hampton case, he had originally had 3 charges, and the count 1 was dismissed. It was a felony, and then count 2 and 3 were before you. But I wanted to know if it should have been count 3 that should reflect the driver while license suspended.
I suppose if they didn't amend the complaint, then yes.
Okay, I just want to make sure because it had count 2 on there. I just didn't want to.
So, Ms. Stevenson, So then actually the first one you sent me might have been correct because this count 2 was the reckless driving count. If it started out with 3 counts, I mean, I don't know because I'm not looking at the file. So if it started out with 3 counts,
I'll look at the ROA and send, if I have to, I'll send it. I'm pretty sure I need to send a different one and I'll do that.
So count 3 was license suspended.
Just tell him that we'll mail him his order because she's gonna have to redo it.
Okay.
And in that case, I'm gonna need his advice of rights form scanned over to me, please.
All right, have him fill out an advice of rights form so we can make sure we have his current address.
We do. Ms. Ritter as well. Thank you.
All right, so what do we have left? Just Johnson and Houston? Oh no, and Norman.
And I think, I'm not sure, he probably got put back in. Oh, I don't know why he went back into breakout.
Oh, I don't need, you finished with him?
I am.
Well, we can close him down. All right, so I'm ready on Houston. All right, this is case number 224572601, the people of the state of Michigan versus Terrell DeMar Houston. Defendant is charged with 1 count of guns reckless use. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Terrell Houston. Mr. Houston, sir, please unmute and tell the judge your full name.
Terrell Houston, Sr.
What's your full name, sir? What's your middle name?
Terrell DeMar Houston, Sr.
Thank you. Today's the date set for a final pretrial conference. How are we proceeding?
Thank you, Your Honor. Mr. Houston will continue his plea of not guilty. We would ask that this matter be set for jury trial, Your Honor. We would ask for a final pretrial, Judge. I apologize. We would ask for a final pretrial conference to determine the cooperation of the necessary witnesses.
The court is going to continue a not guilty plea on behalf of Mr. Houston and set the matter on the jury trial track. I will set a final pretrial conference for, hold on one second. Final pretrial conference for February 9th. No, I'm sorry, February 8th, 2024. At 9:19. Court will be able to give a jury trial date at that time. And I'm not going to require the people to confirm until the next final pretrial. I feel like they should know if they can proceed or not on this case, on a case, but let's not drag it out if we don't have to. Anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Houston. Thank you, Your Honor.
All right, sir, you're all set. Have a great day. Stay safe.
Thank you. You do the same, Judge.
February 8th, 2024. Thank you.
Thank you, Judge.
You're welcome. Hello? No, that's virtual. All right. Okay. All right, bye-bye. All right, I'm ready on Norman. Oh, no, I'm sorry, Johnson. This is case number 214562701, the people of the state of Michigan versus Shanora Lynise Johnson. The defendant is charged with 1 count of operating while intoxicated. Today is the date set for a review. Ms. Stevenson.
Janice Stevenson on behalf of Ms. Shanora Johnson. Ms. Johnson, ma'am, please unmute and tell the judge your full name.
Hi, Shanora Lynise Johnson.
Thank you. Today is the date set for review. Ms. Stevenson, according to probation, Ms. Johnson was placed on a 24-month probation this year. She has submitted to random urinalysis. However, she tested positive for alcohol on April the 12th. She tested positive for alcohol. And then she completed choices. She completed alcohol, highway safety. She's attending AA, and she's attending outpatient. She still has to complete the victims impact panel, pay her fines and costs. Ms. Stevenson.
So we're going to ask that the matter be set for at the halfway point, Your Honor. The explanation which Ms. Johnson offers for the positive alcohol test, which she does acknowledge, was due to the consumption of medication, Your Honor, that contains alcohol. And since then, Ms. Johnson has changed that medication. Ms. Johnson, which medication were you taking, ma'am? Unmute for us, please.
I saw her. Why was she on cough syrup?
Ms. Johnson can explain that to the court as well, Your Honor.
Okay, I saw muted. I was on cough syrup because I have chronic asthma, and I was having asthma attack, and I was I was sick. My doctor, you can get the prescription from my doctor and everything. I was sick. He had me on cough syrup. I was very sick. But once my probation officer told me, what she say, NyQuil, all that type of stuff, you can't take that while you're dropping. And I told her, well, I was sick, and she said, just don't take that. So from now on, I just do the tea and regular herb stuff. I don't even take my steroids for my asthma anymore, because I don't want to drop dirty anymore. And it's not because I had alcohol consumption. It was literally from.
Well, you did have alcohol consumption. You did have alcohol consumption. It was just the source of the alcohol consumption. So
I'm just not going to do that anymore. I'm not doing it anymore. As I told my doctor.
You some salt lamps, and I'm just gonna say that, and then I'm gonna let that go. Yeah.
Salt lamp?
Invest in you some salt. I got one sitting right here on my desk because I got chronic asthma too. Yeah, let's invest in a salt lamp. I'm gonna stop my little virtual. Let me see some. Yeah, I got chronic asthma too. That's why this salt lamp is sitting on my desk right now.
Okay.
Yeah. But what we're not going to do is take cough medicine that has alcohol in it.
No, I didn't take it no more because I didn't want to get in trouble. I told my probation officer, I said, well, I won't take it no more. She said, you cannot take none of that. I was like, okay. And ever since then, you know, I just have to deal with it. I get on my ventilator, you know, I got 2 inhalers and I don't even take my...
I used to have 2 inhalers too until I started sleeping with a salt lamp next to my bed.
Okay.
I used to have 2 inhalers. I used to have all that too, ma'am. I want you to look at Now, I'm not a medical doctor. So, but they're not going to tell you about the salt lamp. I'm just telling you what helped me.
I'm going to go give me one. And then all that smoke been going on. I've been so sick.
Yeah. Everybody I know that had asthma, they've been having so many issues with the air quality, but I haven't had no issues because I've got my salt lamps. Okay. I'm telling you the truth now. I
promise you, I'm gonna go get one today because it don't be feeling good. I be feeling like my chest caving in. I do not.
I have one on my desk. I have one down on the bench. I have one next to my bed. I have one on my desk where I work when I work from home. All of that, but that's what worked for me. That's all I'm telling you. Now don't.
Okay.
And I stopped. I stopped taking I haven't used an inhaler since May the 25th of this year.
Okay. I'm always good for home remedies.
And I had 2 of them too. A daily inhaler and the rescue inhaler.
Yeah, that's what they got me on, this red one. And then they got me on a blue one.
Yeah, mine was red and purple. See?
Steroids. I don't want to take the steroids. That's what make me chunky.
Okay. During who's saying? I mean, who was working with me? Chris. He didn't put a bond. It's not a bond. I think they on his desk. Is that when it's some stuff on his desk?
Well, I'll look at it and see. Or it's only, I think
well,
like just 3 cases that need a bond.
Okay.
I'll call you when I get back.
Okay. All right. You're welcome. All right. Okay. So otherwise, ma'am, you have done a great job. That was not, where's my calendar? Oh, that was, you have one hiccup in a report that's full of good things. So I'm not going to violate you, but your probation officer is correct. You cannot consume alcohol in any form. And I'm going to continue you. So I put her on 24 months in March. So she's not eligible for early discharge until March of 2024. You want me to continue her to March of 2024?
I do, Your Honor. She still has, I think, almost, if not all of it, most of the money to take care of, and she'll be able to start turning her attention to that once she gets her daughter off to school in the fall.
All right, let's have her come back. I could do March 15th. That's a Friday. Otherwise, she could come the next following week.
I think the 15th would be great.
All right. I'll continue her to March 15th, 2024 at 10 o'clock. Anything further?
Nothing on behalf of Ms. Johnson. Thank you, Your Honor.
You're welcome. I got it on Amazon, Ms. Johnson. Just so you
okay.
know. All right.
I'm about to go find me one for real because I'm sick right now, but I'm still trying to get through it.
Well, I'm just that's been my experience. Look, I want you to Google it first. Google salt therapy for upper respiratory issues. It's Himalayan sea salt lamps. But look that up, and then if you want to buy you one, buy you one. But
I'm gonna try it. I promise you. I'm about to get off this now and Google it and go on Amazon and get me one. I'm so serious.
Well, it helped me. That's all I can tell you. It helped me, and I haven't used it. I used to have them sitting right here on my desk with a big bag of cough drops and a big thing of water and my inhalers. But that's just what helped me.
I'm telling you, this right here, this helped me. I try to drink this a day because these steroids, they make me so fat. I be trying, and I got a humidifier. So yeah.
Yeah. All right. Well,
thank you. Y'all have
I hope it works for you. You let me know in March when you come back if it hurt.
I'm gonna let you know.
All right. Bye-bye.
Okay, bye-bye.
I'm ready on Norman. This is case number 452. Oops. 16452-1001. The people of the state of Michigan versus Deron Norman. Defendant is charged with 1 count of operating while visibly impaired. Today is a date set for review. Appearances, please.
Janice Stevenson on behalf of Mr. Deron Norman. Mr. Norman, sir, please tell the judge your full name.
Deron Norman.
All right, today is the date set. For review. And let me see. Mr. Norman was placed on probation for 12 months back in October. This is his halfway point, but he's not near ready for discharge. Ms. Stevenson. And he tested positive for alcohol in May. And this is his second go round with the probation. He's failed to report in April. He failed to report in April and July. It's not looking good. Ms. Stevenson.
Your Honor, I would agree with that, and so would Mr. Norman. And having had the opportunity to have a kind of a frank discussion, he does understand that his freedom at this point is hanging in the balance. We do want to draw the court's attention to those 2 conditions that Mr. Norman has complied with, Your Honor, in addition to coming to court as he's ordered to do. So he does have some work to do. He does have some time to do it, and he does want to do it instead of going to jail. So I'm asking the court to give Mr. Norman the opportunity to continue to move toward compliance, Your Honor.
This is his second chance. This is at least his second chance. Because they saying back in 2020, he started treatment. This is 2023. This is 2023. So we're not going past October 2023. We're not going past 2023. If Mr. Norman doesn't want to do the probation, we can just do the alternative to the probation. If Mr. Norman fails to report to his probation officer, I'm revoking his probation. As a condition of probation, Mr. Norman, you are to report to probation on a monthly basis. On a monthly basis. On a monthly basis. You are not to consume anything containing alcohol. It looks like I converted fine, costs, and fees except $260 to community service, and you've only completed 17 hours. This is a lot to do. Probation is a lot to do. And the only benefit to the probation is that it keeps you out of jail. I won't say the only benefit because services, the rent we pay for the space we occupy, everybody should be doing community service. But one of the benefits is that it keeps you out of jail. But if you don't want to do the probation, we're going to go to the alternative to probation. I'm going to set this matter for another review. This is July. That was October. I mean, Ms. Stevens, he only has 3 months. Let's be realistic.
Yes, Your Honor. I just I didn't want to ask to
3
push
months
it
to complete 97 hours of community service, to report every time he's ordered to do so to his probation officer, to do the alcohol highway safety, to do outpatient treatment and view the consequences video. He hasn't done that in 9 months, and we think he's going to do it in 3.
Honestly, I don't, but I do think that rather than asking the court to give me as much time as Mr. Norman needs to fully comply, at least if we get to that October date, I think he would be able to demonstrate to the court that he's ready to do what he needs to do to get this done.
All right. I don't believe it. Mr. Norman, well, you had your hand up.
Yes, Your Honor. I'm just having a very hard time, Your Honor. I work the night shift. When I get off at 6 in the morning, I get off at 5 in the morning. The bus doesn't come until 7. And then I have to be to probation by 8. I can't make it. I have to get home to take my child to daycare, and I have to try to get the little rest I can to get back to work. I'm just asking if there's any way you can help me so I can get my license. I went to the Secretary of State. I have a vehicle. If I can get my license, it would be much easier for me. Trying to get around with an Uber and the bus routes, the way they run, I just cannot. I cannot. And that's been the holdup. I've been trying
That's not the holdup. The holdup has been that you did nothing from 2020 to 2022. That was the first holdup. The second holdup is I don't have anything to do with you getting your license. And now that you've fiddled around and waited too long, but certainly if he can't do the few conditions I'm giving him on this doc, he definitely wasn't going to do the conditions in sobriety court in order to get a restricted license. So I'm not the Secretary of State, and I can't give you, I don't have anything to do with the licensing. The fact that you don't have a license, I don't know why you don't have a license. It looked like the license on this case would have been suspended back in 2020. So I don't know why you don't have a license. You need to ask the Secretary of State why you don't have a license.
May I speak, Your Honor?
You get ready to try to tell me what somebody else said. Go ahead.
I'm sorry. I went to Secretary of State. They said whoever issued the ticket, this is the only thing on my driving record. They say they have to remove it. So that would have to be 36 Court District, Your Honor. I don't know what else to do.
36 District Court didn't issue you a ticket. The person at the Secretary of State should stop giving out legal advice. 36 District Court didn't issue a ticket. Now, the police officer issued you a ticket if they saying whoever issued the ticket. And if it's your fault that you didn't pay the $45 reinstatement fee, that's your fault. That's on you. I don't have anything to do with that. Your license probably got suspended when this thing first came up. When this case first came up, the Secretary of State suspended your license. So tell you go back to the person at the Secretary of State, tell them Judge Bryant said stop giving out legal advice because they don't know what they're talking about. That's number one. Number two, we can't remove nothing from the Secretary of State. That's a state agency. They have requirements and rules. If you don't pay your fees, you can't get your license. They don't have nothing to do with me. In fact, there is a strict rule from the state of Michigan Secretary of State that we cannot even waive the fee. So the person who's telling you that don't know what they're talking about. But let me tell you who know what she's talking about. Me. I've been doing this for a long time. And so you need to go to the window and pay your fees. And then when you pay your fees, it can be lifted from 36 District Court. The Secretary of State, as I indicated already, are the only people who, if they choose to, based upon whatever rules they have, can issue you a temporary license, a restricted license, whatever other kind of licenses they issue from the Secretary of State. They didn't teach no class in law school about licenses. They didn't give me any authority about licenses. And the only judge that I know of in this court that can ask for requests or do whatever they got going on with those restricted licenses are the sobriety court judge and people in the sobriety court. Otherwise, that's between you and the Secretary of State. So as I said before, these are the requirements that have to be done. Now, maybe your lawyer, I don't know if they advise on traffic things, but I don't do traffic cases and I don't know the traffic laws like I used to when I was doing traffic cases. What I know is that I have nothing to do with the fact that your license is suspended. What I know is that we didn't issue you a ticket. What I know is that the prosecutor's office issued a complaint against you for drinking and driving. So, and what I know is that the prosecutor's office has nothing to do with reinstating licenses. So that sounds like somebody at the Secretary of State don't know what they're talking about. Nonetheless, you could pay your $260. Miss Sealman, does the $260 include, because his fees for me should only be $210 if I did what I normally do. Nonetheless, the $260, does that include his reinstatement fee to the Secretary of State?
Let's check. Let's see. It's on here, so yes, I do.
Yeah. So what they should have told you is pay your money, pay your reinstatement fee, and then you can get your case reinstated. I mean, you can get your license reinstated.
Excuse me, Your Honor.
Yes, go ahead.
So I actually did make a payment of $300. Do you guys see that?
When?
That was last month. I came down to 36 for, not last month, the last time I seen Mr. Bradfield. So last month sometime. And I came down there, I tested, and I paid $300 at the window.
Miss Ritter? I mean, not Miss Ritter.
He's correct, Your Honor. June 12th.
So why didn't his balance go to zero then? Does he have other cases at the 36th District Court?
He has a balance of $260.
Right, but why? I converted 97 hours to community service. Why would he have a $260 balance if he paid $300? What was his amount? And he's only on a 12-month probation. That math that's not mathing up.
And they got it on here, but I don't think they wrote it in the body of the register of action, but I don't believe they actually took it off. So that's probably why.
When you say they wrote it in the body, you talking about the community service conversion?
Right. They wrote it on here. I see it. It says convert $970 of the balance to $97 of community service, but they didn't go inside and actually take the money out.
Can you take the money out?
Yeah, let me. I'll print it out.
So $45 of that money goes to the Secretary of State, and they should be able to give you a license.
Thank you, Your Honor.
And tell them you're gonna go back to the same person. He like, Judge, I'm gonna just stand in line, and when they call me up there, that's who I'm going to. I'm not asking for the person. No, I know. All right. So now that you can go get your license, if this is the only thing that you have, like they said, and now we're going to send them their $45 and they are going to reinstate your license, right? Are you going to finish this probation so I don't have to put you in jail and then you can't take your kids to daycare and all of that stuff?
Yes, Your Honor, and all my intent to get this over with.
Okay, and then stop drinking.
Yes, Your Honor.
Okay. All right, I'm glad we had this talk, Mr. Norman. Let's continue you to the final review, but I need you to pick it up. I need you to pick it up. October 26th is your next court date. Let's see what time. I have some 1:30 cases. So do you want to come at 10 or 1:30?
10, Your Honor.
I'll set you for 10 o'clock. October 26th, the clerk is changing the information. And so the money that you paid, it will go towards your reinstatement fee to the Secretary of State. And they will reinstate your license, okay?
One more question, Your Honor.
Yes.
I do appreciate you helping with the community service, but being that I put 300, is it still 97 hours I have to complete, or?
No, it'll go down by 4 hours. Let's see. You paid 300. How much did you pay?
300, Your Honor.
So the 210 was the mandatory cost. So that's $80 left, right?
Yes, Your Honor.
It'll go down by 8 hours. So now you have to do 89 hours. And then here's the thing. So Mr. Norman, because I don't want to put you in jail. I promise you I don't like them. If you need less community service, if when you get your license back, that help you go to work easier, and that even though the gas is high, that might be more expensive than riding a bus. If you are able to pay some of the money, then I will strongly consider, as long as you have stepped up your game, I will strongly consider playing ping pong. What do I mean by that? Turning the community service, some of the community service back into money. If you feel like you could pay versus, but you have to have completed. Only way I'll consider that, you have to have completed the alcohol safety. You have to have either gotten back in treatment or gotten a letter from the people saying you don't need treatment. You've already paid your court balance. And so I'm going to make a note. So you at least have, and you have had to view the consequences video. So if you've done those things, I'll consider, if you want to let you pay instead of finish the community service, okay?
Thank you, Your Honor.
You're welcome. But I'm writing a note because I'll swear that I didn't say it. So let me write this note. Because this is something that I don't normally do. All right. Anything further? So we're going to continue him to October the 26th at 10 o'clock. Anything further?
Nothing further on behalf of Mr. Norman. Thank you, Your Honor.
All right. Give us until the end of the day to finish inputting and making sure that the register is correct so that you could go to the Secretary of State and they can reinstate your license, okay?
Thank you, Your Honor.
You're welcome. Have a great day. Stay safe.
All right, you too.
Thank you. All right. Who is this in my waiting room that just came about 10 minutes ago? Do we know?
I do not.
I don't see anybody by that first name in the thing. We're getting ready to be done until the afternoon because I'm going to be in a different location.
Okay. And then Judge Ms. Garrett, Ayana Garrett.
I saw her in my thing, but when was she supposed to come?
She's supposed to come tomorrow, and she has told me, she texted me and has called me numerous times telling me she's sick and asking if she can reschedule.
Didn't I reschedule her to tomorrow?
Yes, Your Honor.
Okay, no, the answer is no.
Okay. Secondly, I submitted an order, a motion, I'm sorry, for Valencia Thomas Smith. Back on June
KP is her yesterday.
No. She had that got dismissed yesterday.
Oh.
But there's a she has another case that's going on, and I requested that some of her that her costs and fines be converted to community service.
You
and
requested
I
that
haven't gotten her.
or you sent it to the clerk?
Well, I don't know who I sent it to. My note just says that the Register of Actions at June 20th says forwarded to judge for review.
On what day?
June 20th.
Let's see. I wish they wouldn't forward me stuff for review without letting me know. Do you all want me to count the number of emails I got on June 20th? You don't. You
No.
don't? Right.
No, I don't.
Okay. Okay. Let's see. June 20th. What's the name of the person?
Valencia Thomas Smith.
June 20th. Let's see. I'm still going through the emails on June 20th, just so you know.
Do you want me to resubmit it?
Oh, I should have put, okay. Oh, we didn't know who it was. Okay.
Okay.
So yeah, here it is. And he did send it to me. And why am I doing this?
So I'm asking if she could do 100 hours of community service in lieu of $1,000 costs and fines, because she doesn't have the money to pay it.
Did she do her other stuff?
I don't have an answer for that.
Don't matter.
Okay.
What's her last name?
Thomas Smith.
All right. Anything else, Miss Stevenson?
I could go like for some spaghetti and French bread.
Whatever. There's Miss Ritter.
Really
Okay, let's do the dates because I want to go.
Okay.
The dates, let's see. I don't know why Norman is up at the top, but that's all right. We're going to give a new date to Fuller, Jordan, Nelson, and Polk. Also, Vincent, Williams, Ross, and Wilson. So that's 1, 2, 3, 4, 5, 6, 7. 7 people at the 8:30, going to be scheduled at 8:35 on September the, let's see. They're gonna be scheduled on oh, let me write this down here. September 11th at 8:35. The person at 8:34 is Capius. Their bond is 5,000, 10% plus GPS tether. Person at 8:36 is probably not Capius. I don't know. Explain it where this was from. Gant can go on 9/11 at 8:35 as well. Portia Allen is Capius and their bond is 2,000, 10%. Ratcliffe is Capius with the regular bond. That's it. Ms. Stevenson, you need to contact your client for the Patrick Ashley case. Ashley Patrick, Patrick Ashley, Ashley Patrick.
Right.
Monday.
Right.
Ms. Ritter says somebody not answering the phone. So
we're still live.
Oh.